Dana Florida versus Sarah Boone, 2020 CF 2603.
Murder trial involving defendant Sarah Boone. She's accused of second-degree murder after she zipped her boyfriend up in a suitcase and left him there to suffocate and die, according to police, back in 2020.
She said she was playing a game. That video does not sound like any game I've ever heard anyone play.
She's the one who talked to the police officers. Again, you have the right to remain silent.
The problem is I fell asleep. I fell asleep. When
You fell asleep?
This segment's brought to you by Don't Talk to the Police.
In her mind, that explanation was sufficient. She's practiced that. That was something that she looked over and say, I'm gonna just say this and they're gonna understand me. It's bad.
In this case, the suitcase is the alleged murder weapon.
Defense attorney turnover rate has been high for Boone, who has cycled through more than 4 different lawyers since her 2020 arrest.
You have these criminal defendants that, are narcissistic. They think that they're the victim, even though they've engaged in these horrific crimes.
This is bad. This is bad. So it's so bad that any attorney trying to tell her how bad it is, she's not going to listen.
they're going to think I killed him. First of all, no one asked her that question. She's being interviewed. She's kind of frantic. And then she just blurts it out. It's interesting subconsciously what is on her mind.
Everything that she did afterwards. And what the hard part is, it's her own doing. It's bad.
Hi, everyone. How are we?
Hello. Good afternoon.
Good afternoon. How are you, Miss Sam?
I'm a little tired. I got up at 4 so I could work so I could come here and be with you. So now I'm tired.
Oh, I get you. Okay. I tried to take a nap because I got up super early too, and then I couldn't sleep. I was like, have y'all ever done this? I was working in my dream. And so when I woke up, I just felt exhausted. Like I didn't rest at all. Good to see everybody. We've got 266 already here. Wow, you guys.
Hi. Welcome back.
We're going to talk about what's going on with the docket right now. And I guess I could screen share that.
All right. I'm seeing you all. Carrie gave me too many permissions, so I can't comment as Sam. I comment as Carrie. So I'm just saying hi to everyone.
So on the docket today, what's been uploaded is they've got a list of exhibits amended. They've got a notice of provision of witness list. And then they've got, what else was the other thing? They sent a copy of the amended list and another notice of witness list. So you got Owen sending one. You've got the prosecution sending one. We don't see the list, so it's kind of boring.
Right.
But Sam and I were just talking before we went live about this motion to suppress and the importance of it and what wasn't said. I know we've already gone over this in my previous little docket dive, but Sam, do you want to have you looked at it? It's basically all he did was he took off. Let's see, he amended the part where he said she was there for 14 hours. He took that and changed it to several hours. He didn't make any new, in any of the wording that he changed in here led more towards something that helped them with their thought process on this. There's no case law. It's the same. I mean, it was just minute changes. Like I could have gone in literally as a layman, I could have gone in and changed this and amended this and sent it in to him and go, yes, I fixed it. Go ahead.
So I skimmed it. And yeah, I am unimpressed. First of all, it was late, right? Wasn't it supposed to be filed by the 27th? And it went in on the 30th. Oh,
yeah. Yep, exactly.
So, because I kept checking the 27th, looking for it. And yeah, I don't think that the judge is going to find this all too persuasive because there's no case law.
I feel like he's gonna just not even. He's gonna say, "Yeah, you didn't get it in on the deadline." James Owen has made a comment early on, and I caught it the other day when I was doing some clips. He says, I just wanted to get it in there, Judge, and then we'll talk about it later." And I know
Yeah,
I've said that before. He already made that comment that he can throw stuff up there and then he'll fix it later, but he wants to get it in for the deadline. Well, obviously
that's
he didn't meet the deadline this time.
yeah, but that's behavior I think he learned in his home court, right?
Exactly. Yeah.
And that is not acceptable Judge Cranick behavior.
Yeah. It's funny because I was looking on his I did a little short thing about the comments in his, I might show it if we have time, on the reviews that he got on his webpage.
Oh yeah, I haven't
And
seen it.
all the positive ones, you could tell that they know him personally. But do you know that there's somebody on there that complained that he actually dumped her case in the middle of it after working on it for a year? He dumped her case to get to go to Sarah's case.
No, I didn't know that. Like, where are you getting this information from?
It's
What are you referring
it's
to?
just Google reviews. It's Google reviews from his, what do you call it?
Oh, like
I mean,
his
yeah,
presence on the
from
internet.
the website, from his website. Yeah, you could go on and Google review any business out there, right?
Yeah.
And the beauty in Google reviews is that you can't fix it. You can only respond to it.
You can't delete the bad comments.
Yeah, you can't do that like you can on Facebook. But yeah, she said he'd been in my case for a year, and then he just dumped it. And now I'm scrambling, still trying to get paperwork from him, not sending me the paperwork I needed. I could see, okay, so here's my thought process. A good attorney, if that were to have happened, a good attorney would have said, you know what? I got to take on a big case. So what I'm going to do is I have somebody over here I want to refer you to. He's a local attorney. His office isn't far from mine, so you don't have to drive that far. And I'm passing him the entire file for you, and he's
Hmm.
it's on for you. That was what a good attorney would have done. It does not even sound like he did that.
No, it doesn't sound like that. That's horrible. I feel very bad for that person.
Isn't that bad?
Hmm.
Uh,
Especially since he took so much time in contemplating taking the case, you would think that he would have made arrangements for his other clients, but maybe he thought Cranick wasn't going to keep to the time frame. Maybe he thought he was going to get more time.
I think he did. I think he thought he could get in there and weasel
Hmm.
his way out of it a
Yeah,
little bit.
right?
I've been listening to a lot of older clips on court TV on this case and what the defense, them talking about the defense and everything. And there
Hmm.
was a couple of things I clipped that I'm going to go through. I want to talk today, like the rest of this week, as
Hmm.
much as I possibly can. I'd like to focus on what we think the strategy is going to be for the defense. I mean, we know what they're trying to do, but also focus on, what do you call it? The play-by-play of what the prosecution is going to do, how they're going to come back with things. I mean, I'm curious, and I want to know, like, if Cacciatore or Jay is going to do the opening.
What do you think?
I don't know. I'd prefer that Jay do the closing. I think. If y'all can hear my dog panting, he just went outside. It's very hot here today, so he's laying under my desk, of course, right up underneath me, and he's panting heavy.
It
Don't
is
worry, I did give him
hot.
water. He's got plenty of water.
It is hot outside.
Yeah, it is. So that's the panting you might hear behind me. I do apologize. I try to fix that to where he can go out and cool down before I go live, but somehow or another today that just did not happen. Yeah, I don't know. I think I would like to see. I don't know. It seems like jury's really paying attention at the openings, maybe more so than the closings. I'm not certain. I don't know. I've never really sat through a trial as a juror, so I don't know. What do you guys think in the chat? Would you rather see Cacciatore or would you rather see Jay do the opening statements?
They're talking to each other. They're not paying attention to us.
Oh, they're catching up with each other. That's good. Good for
Yeah,
y'all.
they're saying
I'm telling
hi.
you. I'm
They
telling you.
carry on. They carry on their own conversations.
Will jury selection be on court TV? Will it be aired? I don't know if they're going to air it or not. All I know is that they did have
Hi, Laura.
a previous trial that we watched. there was a jury selection shown. It was from the state of Florida. Again, I think that's up to the judge. I don't know if Cranick's going to go there. I really
I don't
don't.
honestly. Okay, my guess is can only be a guess. My guess is he's not going to allow media to the jury selection.
But I did see something up as I was going through all this stuff. Oh, by the way, I'm changing over to purple today, y'all, because for domestic violence, we're gonna do purple for my background drop, my colors. I saw something where they have the 7th listed as their go date. I think it was they've got it scheduled to stream on the 7th, so they might show something.
Court TV or Law and Crime?
I think it was Court TV. So I guess we could just, I plan to be here with y'all. And if you guys want to hang out, the worst case scenario, they don't show it. They show a little bit here and there. And then we still stay and talk about stuff on the case. And then we could plan to see what happens the next day. Speaking of all this, I wanted to throw up real quick and watch this really quick video of how Cranick has it down pat as to what we're going to do when it comes to jury selection.
Okay.
So what people know about this case. So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you. Go home. You don't need to show up for jury service than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous.
Fabulous. Fabulous. I love how he did that. He was like, this is what we're doing. This is how it's going down.
He thinks so far ahead. It's awesome. I'm so proud. LW in the chat asked me if my person in the courtroom knew who Sarah was making happy kissy faces to. And the answer is I asked and they did not know.
I think she has somebody that's either written her in jail and become like one of those people that gets attached to people because of their infamy or whatever they call that.
Infamy, yeah.
Or it could be that maybe there is a long family member. I know, remember there was a family members, like a couple that was visiting her that seemed like somebody that she'd known before because they started visiting her like right away. There could be family friends or something that are standing behind her right now. There's not many people standing behind her, I don't think.
No.
I mean, I don't see anybody from South Korea, North Korea, whatever, coming down to hang out at the trial in Florida.
Oh my gosh. Some people think it was Billy Lane. Guys, I'm going to tell you something. I know Billy Lane. I know him actually a lot better than I've let on. And I can tell you for a fact that was not him. So Sarah's got herself another paramour or family supporter.
So it is 1:45. We're about 15 minutes away from when they start this hearing. I'm curious as to what you think is going to go down here, Sam, because the judge says he's going to hear this other motion to suppress, which I feel like he's going to come in and go, yeah, you didn't meet the deadline, it's done. But the other motion with the hair and makeup, he does not, he wants to do that in his chambers. So can you tell me what you think is going to happen there?
They want to do that in chambers. Oh, wow. So yeah, he'll come in and, you know, set the record, say who's present, what they're there for. I'm imagining that he would address whatever is going to happen publicly, the motion to suppress that has no backing whatsoever. And maybe address these amended, it looked like there were maybe some amended lists put in there today. I've been working, so I'm not as caught up. And then I guess they would go in chambers to talk about or maybe they already have talk about the hair and makeup
Okay, and
situation.
then they'll air it. That would make sense, and then they'll air it out. Well, you know, if they don't,
They put it on the record. So like if
yeah,
they do it in chambers, they've still got a court reporter with them,
right.
right?
Okay.
And whether they come out and say it like publicly where we can all see it, I do not know.
Why do you think he decided to do that in chambers?
I don't know. I've never seen, oh, Alexis W is saying because the clothing and restraints. But the thing is, all of my cases, they all get civil clothes for trial. I mean, that's just like, that's part of the deal. Haven't had any females go to trial, but all my guys have to change, they all for their trial every time they come in and out. So I don't understand why. Maybe because of the skirt thing. I don't know.
Well, I know this is because they're putting did they change the motion to say makeup? I can't remember. I've gone through. I haven't looked at it today because I'm just.
Rose is saying the new motion just posted to the docket. Listen,
Okay, I'll
you
pull
all,
that up.
I cannot keep up.
Read Janice's comment here.
Okay, yeah, hold on.
On the screen.
Janice Wingfield says, "Thank you for your super chat. Owens was wrong in his motion. The first phone call Sarah made was to Brian. He had to tell her to call the police.
That's
Who
correct.
doesn't know to call the police when finding someone deceased? Lordy, she didn't.
She is dense.
I agree.
Oh, okay. Oh, no, he did not. It is a motion to suppress that just hit the docket, and it's so new that the papers haven't uploaded yet. I have to refresh it a couple of times. Last time this happened, it took me a few minutes, and I kept refreshing, and then finally the paperwork was attached where I could open it.
Are you kidding me with this?
But
Do you
it's
think
3 pages. It's
Okay.
3 pages long. The last one was 5 pages long, so it may not be the same thing.
Interesting. I love the state's snark. So whenever they post file a motion back, I love reading those because he's just just beautiful with his words.
He really is, isn't he? It's professional.
Masterful.
Yes, it's professional with just a little side of snark. Yes.
Oh, 100%. I love it so much. Really, I do.
He's like, don't put that snark on the side, on the top. Just put it on the side. Thank you so much. When you put that in my to-go box.
Oh, it's so good.
I'm still refreshing this, guys. I tell you what, let's do this. I took some clips from. We've got about 10 minutes. I took some clips from when. Thank you for your super chat, Janice. From when Dr. Brannon was interviewed. Now, some of these go way back. He was doing Arius, was one of the ones he was talking about. He even was talking about the Jerry Sandusky guy. But what I want you to what I want you guys to pay attention to is the types of disorders that he's talking about and what he's saying about them. Because I swear to you, all of them describe her. Okay, let's pull this up and play it.
Personality disorder that's diagnosed in the Diagnostic and Statistical Manual, kind of the Bible we use as psychologists and psychiatrists. It is a disorder which is one in which a person tries to get as much attention as possible. They're a heat-seeking missile for attention. They're usually very dramatic people. They want to do everything they can to make sure anyone and everyone makes them the center of attention. And in the process of doing that, they oftentimes misinterpret relationships, thinks that people maybe have a sexual interest in them, or they may become inappropriately sexual or provocative with them. So that's all part of, or can be part of, this personality disorder. So
I want to bring in Dr. Michael Brannon. He's a clinical and forensic psychologist, a great one at that. He joins us now. And Dr. Brannon, I'm going to ask you to do something really hard here. Get into Jody's head and explain it to us. Now, you've talked about how Jody has shown chameleon-like qualities during her statement to the jury yesterday. So what do you think accounts for this, her lack of empathy? Let's put it that way.
Well, Ryan, it's always difficult to say when you haven't actually spoken to the person, but she's given us a lot of samples of her behavior. And in terms of when she does relay something or speak, she certainly seems to have a disconnect, if you will. It's almost like sham emotion. She's pretending to have certain emotions or trying to copy certain emotions. So even when she's given the cue about feeling sorry, she kind of acts like a person maybe should act when they're sorry, but without the emotional content behind it. So she really has a disconnect, and I think it speaks more to her personality type than anything else.
So she's not really sorry. She's simply saying the words and acting the part.
Well, it seems like, again, she doesn't have the ability to experience those emotions like other people like you or I or other people without her personality structure would feel. So she's trying to copy or mirror things. And that's why I think she presents things in a chameleon-like way to whoever she's in front of. She does a lot of what we call impression management. She's carefully trying to posture how she thinks she should appear in front of a camera, in front of a jury, in front of her attorneys, whoever, whatever the case might be.
You know, my colleague Jane Velez Mitchell always likes to say Jody's acting like she's in a movie. And it makes me think that maybe she likes to take on roles like she's in a movie of, for example, the abuse victim and the person who's not hated but is loved for what she's been through. What's your take on that?
Well, Ryan, it really depends on if you want to perceive her to be this volitional individual who's purposely doing this to manipulate everybody, which is easy to do. It's like making her the all-the-time bad Jody. She's always bad. But people aren't all bad for the most part. They're combinations of different features and factors. And this isn't to stick up for her to rationalize her behavior in any way or awful behavior, but it's to say that she's probably a mix of a lot of different things. And if she truly is personality disordered, like what's been suggested by some of the psychologists who evaluated her, the way she's acting and behaving may not be volitional at all. It may show the deficits or the inadequacies that she has as a person, connecting her feelings, her emotions to what she's saying and to what other people might feel in the same situation.
Right here from the DSM-4 on page 710, diagnosed her as a borderline personality disorder. Well, the same doctor analyzed Marissa Duvois, and you have to turn back 2 pages to page, 706, or actually more than 2 pages. It's actually 4 pages back to 706 to get the diagnosis of Marissa Duvois by the same doctor in the same courthouse. Take a listen. So the doctor finding Marissa Duvois, 7 characteristics of an antisocial personality disorder. Let me bring in my guest, clinical and forensic psychologist Michael Brannon is in Fort Lauderdale. Great to have you all here. All right, Dr. Michael Brannon, who's more dangerous, the Jodi Arias borderline personality disorder or Marissa Duvois' antisocial personality disorder?
Depends on when you get them, Vinny. I mean, they're both very serious personality disorders. One has more to do, a borderline personality disorder, has more to do with relationships, problems in relationships, and always having concerns of abandonment. So around the time of abandonment or fear of loss of their significant other, the borderline personality disorder will certainly be more dangerous, if you will. Whereas with an antisocial personality disorder, and by the way, the DSM has now moved the DSM-5, Vinny, so we've actually made some progress from what you showed. We actually have a new book in the last year, the DSM-5, so tell them to get you a new book. But the antisocial personality disorder, they have a general lack of connection with people, an inability to empathize or show remorse or connection. So they're generally more dangerous throughout each and every day. So as a standard, they're more dangerous, but there's periods of times when a borderline personality disorder may be very dangerous.
JPC says, will we find out today if Sarah gets any appointment with Glamour Shots? Oh, if only Glamour Shots was still around. My goodness
I was
gracious.
going to say, do they still exist?
No, they
Glamour
shut them down a
Shots?
long time ago. They got shut down in the 80s when the hair went down. When they said, nope, no more perms. That's it, ladies. We're going straight.
Oh, man.
Straight hair only. So what do you guys think about what he said there? I just thought that was interesting because of all those clips that I found, that is Dr. Brannon. That is the one who they're going to bring in to corroborate what Dr. Julie Harper is saying. They're supposed to depose him tomorrow. What do you think, Sam?
I think that I can't predict anything when it comes to this case or this trial, and who's going to say what. I mean, I will be getting up at 4 a.m. every day so that I can do a whole bunch of work before court starts, so that I can sit here and watch this because I have to see it now. I have to see it play out.
I don't know if there's going to be any time in here that's going to be boring. I think the only time that we're going to be rolling our eyes and saying that we need a drink is when Owens gets up there and won't stop with his antics about arguing a point that the judge has already said. No. Thank you, Cindy. That's very kind of you, honey. Cindy Buchanan. Thanks for posting this, she said.
Thank you. Oh, man.
I have Law and Crime on in the background, y'all. As soon as it goes live, you will see it here on my screen, so don't you worry. I feel like in some of that stuff he was saying about the attention-seeking thing, that is totally Sarah.
I agree. But also the victim, but you have to be proud that they survived it and that they do everything really well. Do you know what I mean? I think we talked about this before.
Them excelling at everything. Yeah.
But also being treated the worst, being the best. Oh, hey, Dr. Barry. I love your show. I come and watch you all the time.
Susan B., thank you so much for your super chat. Thank you for all the hard work you're both doing. We appreciate you for saying that. Thank you for noticing.
Yes, thank you. You need to thank Carrie because I just log on here and push buttons and break things. Yeah, I don't know. This is going to be so interesting. I'll be interested to see what Dr. Barry says on her channel. She does, Carrie, if you don't know, she does psychology, but looking at the law, like the legal, the psychology of the legal side. Yeah, no, they're not. I'm sorry. But it's really interesting. Her analysis is really interesting. So.
Thank you for coming a member, Ella Blue.
Yeah.
And Miss Carolina also became a member. I thought you were already a member, Carolina. Did you re-sub up? And then look what Mark put up.
Oh, no. What did Mark put up? A whole year of this craziness.
He was actually
Has
kind.
it been a
Thank
year?
you, Mark.
Because you've been a member for 12 months. I thought I saw him, but maybe not. Or I thought somebody was talking to him.
Who was it that said something in the comments? Oh, it was Patty, I think. She said she was cackling over Mark and I the other night. If you guys missed our salacious speculations, you got to go back and watch it. We had fun.
That was fun.
We were just talking about what we thought could be. We brought people up on panel and we were throwing out salacious speculations of what could have occurred that night.
The documents are up.
Oh, I forgot about the documents. Let me do it.
Yeah.
Let me pull it up for everybody.
Can we get some Sarah Boone emojis for this trial for members? I have no idea. You need to ask.
Yeah, I got to work on that. Yeah, I definitely need to add that to my list of to-dos.
Love to create liked our show the other night. Yeah, sorry.
All right, so defendant's second amended motion to suppress. Sam, okay, I need somebody to keep an eye on Law and Crime and let me know when they go live, so I'll stop reading this. Let me pull this up so you guys can see it. If you hear Bruiser in the background, he's mad. I don't know why he's mad. He's a small chihuahua, and he does that. Amends this motion, moving the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office. This is a revision, but it's now no longer 5 pages long. It's 3 pages long. And here's my complaint about this, you guys. Why? He has some balls. He did put see U.S. Constitution amended for. Oh, they didn't put the art. You see number 3?
No, I'm trying to get to law and crime. Hang on. Okay. I'm coming back.
He literally he did put a case file in here, you guys. Guess what case file it was? Miranda.
Oh my God. He filed a motion to suppress statements. Okay. Reiterates the facts and argument.
What is wrong with this individual? Oh, it's up.
Okay. They're arguing Miranda.
Okay, we're going to look at this in the background, and then what I'm going to do is I'm going to pull this up. I'm going to pull up the stream for Sarah on Law and Crime, and then we'll be watching this, and then we're going to be talking about the motion as we wait. Do you want? Let's see. Let me read what it says. On September 30th of 2024, defendant E filed an amended motion to suppress statements at the Orange County Sheriff's Office. Defendant reiterates the fact and argument outlining in the previous e-filed motion, and in addition, they spelled wait. What is that? Avers?
I don't know, because you're showing law and crime, and I can't read the thing.
It's Avers. That's not a word. Is that a word?
I don't know. I gotta see it to tell you. I don't know.
And then they talk about both the United States and Florida Constitution provide that no person shall be compelled to be a witness against themselves in any criminal matter. Where a defendant is subject to custodial interrogation, he must be administered the proper procedural safety guards, commonly known as Miranda warnings. See Miranda versus Arizona. In the seminal Miranda versus Arizona decision, the Supreme Court enunciated this bright line rule to guard against compulsion and coercive nature and atmosphere associated with interrogation, to assure that the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. You know, Sarah, we can't help it that you run your freaking mouth.
Averse is a word.
Averse is a word. Okay.
Yes.
And while the defendant may waive effectuation of these rights, such waiver must be made voluntarily, knowingly, and intelligently. The court must make a case-by-case determination based upon the totality of the circumstances as to whether the waiver was constitutionally sufficient. Therefore, until the Miranda warning and waiver are demonstrated by the prosecution, no evidence obtained as a result of interrogation can be used against the defendant. And then they go on to say that the defendant was in custody for purposes of Miranda. Custody encompasses not only formal arrest, but any restraint on freedom of movement of the degree associated with formal arrest. Trailer versus State. Oh, he found a case. A person is in custody if a reasonable person placed in same position would believe that his or her freedom of action was curtailed to a degree associated with actual arrest. And then it says, here it is, uncontroverted defendant. Here it is, uncontroverted defendant was in custody for purposes of Miranda. On February 25th of 2020, defendant arrived at the Orange County Sheriff's Office, where she was directed to an enclosed interrogation room. Therein, she was surrounded by 2 detectives, and furthermore, Lowen's firearm was visible. I knew they were going to do that on his waist throughout the interrogation. Therefore, it was reasonable for the defendant to believe she was not free to leave at that time. Then it says defendant was subject to interrogation for purposes of Miranda. Interrogation is any questions or actions by the state agent that is likely to elicit an incriminating response. In the instant matter, defendant was directed to an interrogation room where she was subjected to investigative questioning for 2 hours. It is undisputed that the line of questioning exhibited by both detectives was likely to elicit incriminating responses. Therefore, this court should find the defendant was subject to interrogation for purposes of Miranda. You guys, I think it's amazing that he waited till the last freaking minute before they go into trial here today, or hearing, to put this up here.
I think it takes nerve.
He got nerve.
He has not read the room, in my opinion, as to how that would be dealt with late and not very strong. So Tabitha says he did it the last minute so the state won't have time to rebut. Well, the judge can just say he denies the motion to suppress.
I mean, he did put a deadline on it, but the thing about what he's saying here versus what he said in the last one is he's going back to the state going, you need to prove to me that the waiver was made knowingly, voluntarily, and intelligently based on the totality of the circumstances. Did you not see the videos and the audio? What? He's just going through the freaking motions. He did reference North Carolina versus Butler and Ross versus State. I would imagine his other buddies probably helped him on this. A court must determine based on the totality of the circumstances whether voluntary and it's the same wording.
Mm.
He says first the detective minimized and downplayed the significance of the Miranda rights before interrogating the defendant. They have the right to do that. Where police minimize and downplay the significance of the warnings, the very purpose of Miranda is undetermined. In the instant matter, the purpose of Miranda was undetermined as follows. And then he talks about how the detective said, so obviously we received his autopsy. So now I'm going to read you your rights again because we have to talk about that. And we're not done talking about this incident. We just have to do it. And Sarah said, just like we did yesterday and the normal protocol. And the detective said, yeah, just like we did yesterday. Remember I read you the rights? Yeah, it's the exact same thing. But since I'm asking you follow-up questions, I need to read them to you again, okay? And then the last portion of this says the aforementioned line of communication highlights the coercive nature of Detective Koepsell's actions. In addition, it is apparent the defendant believed at the time that she had to speak with the detectives and that the warnings were just a form of protocol. Second, defendant was not properly informed of her rights to make a voluntary intelligent waiver of such. Detective Koepsell failed to ask the defendant, having these rights in mind, do you wish to talk to us now? Finally, based on all the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely and voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. But the thing he did here in this particular thing is he has no mention whatsoever of the other 2 times that she was on body cam and when they spoke to her in the car. So he did specify to take that piece out.
Okay. So the only one he's moving to try to suppress right now is the one at the station?
Yep.
Or yep. Not the car.
The one at the station.
Okay.
Wow.
Like interesting. You would think he would have moved to suppress the previous calls to the house where Sarah asks the cop if they need Jesus right now.
You'd think.
I love that clip. That's my favorite thing.
Oh, let me go over here. We got I got some more people that I need to acknowledge. Mary Jo Freilich, just want to make sure I don't miss a moment of your sight on the 7th. What time are you starting the trial coverage? Michigan start times. Thanks for doing. I don't know what time. Are you on Central, Eastern? What? I will tell you that I have to go back and look. If you go onto my website, I've already got it pulled up and it'll have the time zone listed there. And whatever time zone you have your YouTube set up in, it's going to tell you what time I start. I want to say it was 9 or 8. Let me look on my paper calendar. Oh, shoot. I don't even have it written down on my paper calendar. It's in the morning, though. I know it's in the morning.
Yeah, it may be 8 or 9 or 8:30. You never know.
He
may want to start early. He may start at 8. So we're on Florida time. I don't know where in Michigan you are. I don't know if you're in Central or Eastern.
Let me look really quick on what time I've got this pulled up here. I've got it set for 7 a.m. So it must start at 8 a.m. Eastern Standard Time.
Right.
Which makes sense.
Oh my God.
That's not Florida time.
Carrie.
What?
The state already submitted
a response.
Yes.
I love that you're updating this as you're checking they were ready. The defendant's case law submitted on September 30th regarding motion to suppress filed on September 24th. Okay, well, we got to wait for the document there.
Yeah, it hasn't updated yet.
That's hilarious.
I need
do you think they're in the chambers right now talking about all this stuff?
I have no idea.
Oh my gosh, you guys. I'm sorry. I'm excited and I know I'm talking over you and I don't mean to, Sam. I apologize.
No, it's fine. And I should be sitting in front of more than one screen. Sorry.
I know, right? So, Mary Jo, I hope that we answered your question there. It's Eastern time is 8 a.m., 7 a.m. Central Standard Time. But I'm not sure what your time zone is there.
We're on daylight savings time right now, aren't we? We haven't moved back.
I don't
Emily
know.
H says Law and Crime is live. I've got them up. I think Carrie's
We've got
them
it up
too.
Yeah, that's what we're watching. That's where we are, girl. What you talking about? I just got the push notification that. Oh, that's
Law
what
and
you
Crime
just
is
read.
live. Yeah.
Oh, well, you know what? She was letting us know that from earlier. Thank you, Emily. That's an older.
Okay.
So that's my
Gotcha.
fault for not getting it up there in time. Sam are the greatest. Oh, thank you, Mark.
Thank you, Mark.
I take back every bad thing I ever said about you, Mark. Just kidding. No. Do you know what the beauty in it is that he can take it and I can take it and we can go back and forth and it's just it's awesome.
Jeff Curtis said we are on daylight savings time. We haven't rolled backwards yet, I guess.
Mandy says, "Here we go, boonies. Here we
Snap
go.
and twist.
Snap and twist." I'm gonna snap into a Slim Jim in a minute here when they start talking and I go on mute.
Oh my gosh.
Y'all are too funny. Y'all are hilarious. I love you guys. You know, you guys make doing this so much fun. If it were just Sam and I doing this, we'd get bored with each other.
Yeah, well, maybe, but maybe not because we go off in different directions on tangents all the time.
Oh, yeah, we would have already been on a totally different subject by now.
Oh, somewhere else. We'd be somewhere else by now. Yeah.
Completely.
100%. It's fun to watch. I'm watching the chat. They're so funny.
I'm going to focus here on the people that are doing the super chats while you're doing that and tell you that Janice did another super chat that says,
"Oh, thank you.
I also think Sarah called Brian to help her dispose. No, this is a different one. Dispose of George's body. Brian saw George on the floor in purple and turned around and went outside. I agree. I think that I really do. We said that the other night. We felt like she was trying to get Brian to help her get rid of things. Because why else wouldn't she have just called the cops right away? She was trying to think of a way out. For sure. For sure. For sure.
Yeah.
You know what I just thought about? We know that Sarah's there already because her bailiff's been walking back and forth. Thank you for that super chat, Janice. Oh, here we go. Miss Barbara Steele says, "Look no further, YouTube. If you are reading this, you're the best channel and chat on YouTube." Aw, aren't you cute? Miss Barbara Steele's from Blue Bayou, Louisiana. Is she sitting over there in the corner again, hiding away? We would see her, right? If they went into chambers, wouldn't they have taken her in there with them? Sam, are you reading the motion? You're on mute, Sam. She must be in there reading the motions right now. Let me go over here too and say, Miss Mandy, if her statements get suppressed, the state needs to up her charge to first degree and intentional killing from premeditation. I was wondering about how that would work, and maybe Sam will know when she's done with looking at this motion. I kind of wondered if they could flick around. I guess until the jury is sworn in, they have the right to change the charges up, but that would be very interesting. Thank you for another super chat, though, Mandy. I appreciate you. I'm going over here to wait. Where's it at? I'm looking to see if the state's response to that other motion, their suppression motion. On my side, I keep refreshing the screen, and the paper's not there yet for me to open and look at. It takes it a minute to get there, so bear with me. Sam might already have it on her side. She has Apple. I'm on Windows. I'm on Windows. I don't know if that makes any difference. I'm just being silly. Yes, I felt like Sarah was already in the room because I saw her bailiff walking back and forth, but I could be completely wrong. Oh gosh, we got another one? Will Sarah be in her professional attire today? Where is Cookie's cat? Where is Cookie? Cookie, you in the chat today? I'm telling you, everybody loved you. We might have to bring you on weekly. Okay, what just happened, Law and Crime? They're
Hi,
still
I'm
there.
back. I'm
Okay.
so sorry. I had a lawyer call me.
That's okay. Don't worry about it. Oh,
Uh,
okay. Well, it's not anybody on this case, is it?
Oh no, no.
Okay.
Actually, this lawyer has waited till the last minute to file something in a case I'm working on, which could be a potential wrongful conviction case. We'll see how that shakes out. But I didn't want to text him and tell him, hey, I'm on YouTube, so I can't talk to you right now.
I was worried that you were going to say, Carrie, we can hear you in the courtroom again.
No.
Sam, we were just talking about the whole thing about changing charges. I don't know what you know about this, but when it comes to if they wanted to do first-degree murder, manslaughter, like so if the state's changing their defense. I mean, the prosecution, no, wait. The defense is changing their defense strategy. Can the state go back and change the charges?
No.
Okay.
They'd have
It
to
is what
null
it is.
pros. They could do lesser included when it goes to the jury, but she's on second manslaughter for depraved mind, I think, right?
Yeah.
So, no, they can't upcharge.
They can downcharge. Okay,
right.
good. Yeah, that's what they were asking. Okay.
They would have to immediately file a null pros, which means the notice of non-prosecution, and shut the whole thing down, come back and recharge her. But it would have to be done before a jury was impaneled, because that's when jeopardy attaches.
Yeah. Jackie, I can't see your, thank you for your super sticker. I can't see it here on my end because of the way that StreamYard is, but I know we can see it in the chat in YouTube. So thank you, Mama. Thank you so much. And also, I think I'd already said this the other night, but Boss Lady and Carla became members. Awesome, you guys. This is going to be fun. This is how we do it.
All
Sam's
right.
like, I put stuff in the private chat for you, Carrie, and you never read it.
No, sorry. I'm like, it is still a work day for me, so I'm a little distracted. I apologize. And I thought I had my phone turned. Oh, my stepmother has just texted to say she lost sound on the podcast. What's up with that? I don't know, Susie. We're still here.
Well, let me do a test. Can y'all hear us? Can you hear me now? Can y'all hear us on y'all's end? Of course, there would have been 1,000 people here going, "You're muted, Carrie.
Yeah, exactly.
You're muted again, Carrie."
She might have just lost internet signal where she is. Susan B is a new member.
Whoop, whoop. Thank you, Miss Susan B, for becoming a member. I thought you were already a member. I do want to acknowledge the people over on my other membership channel, which I thought we were going to have a lot more fun on, but I think it's trial and error right now, you guys. It's called Buy Me a Coffee, and I post a lot of stuff that research things that I have and that's behind the scenes that I wouldn't put up on YouTube. But I also do a special email to everybody to let them know that we're going live, or when we're doing when a new video is uploaded. It's a little different, but I'd like to look at the members really quickly and say thank you to them.
Mm-hmm.
And those people are Sam Lott, Kimberly.
Oh, we see Sarah. We don't have a judge, but we see Sarah.
Oh, they put her. Oh, that's right. They had her at the table last time, didn't they?
Doesn't look like she's had her hair done.
Oh,
I'm sorry, Carrie. I did not mean to interrupt you. Thanking the coffee members, the coffee club. That's
okay. Mandy Strong, Key, Michelle, Fan Lady, Linda, Bama Green Eyes, Barbara from Blue Bayou. Is that everybody?
Mandy just gave us a big super chat. Thank you, Mandy. By Sarah now claiming it was self-defense, that reduces her chance for a lesser included verdict. She's claiming it was intentional. That rules out manslaughter. Look at you. You've got a very well-educated chat. How does her hair look worse? I don't know. I don't believe it's been done yet, Rise of Phoenix. Yeah, Matthew Whitehair said something similar, Mandy. I see.
And Robin Matecki became a new member, but Robin, you were already a member, I thought, too.
There's so many things to
You
look
gotta.
at.
I think the reason that okay, so they would have started like 20 minutes ago, but I think that's a big super chat. Thank you, Mandy. Oh my God, girl.
Right.
Y'all are too kind. I would have thought. I think maybe nope. There's Owens right there.
Yeah, so they'll
Maybe
probably
they were
do the
already in
in
chambers
after, or maybe they did it earlier. That's entirely possible. Someone said something I wanted to respond to. Oh, no, so she's not asked to be in civilian clothes for her hearings. She's
Yeah,
asked
she did.
She did for hearings?
Yes, they said we have 2 more coming up, Judge. So we were
Oh,
thinking
man.
we could get her to change. Yes. That's what
Okay,
everybody's isn't that crazy?
completely forgot that part. Yeah, she'll get it for trial. Wait, is this the last hearing?
It's supposed to be, but you know how that goes. We still have a couple more days, so we still have 3 days for
Yeah.
James Owens to whine and throw something up in the fan that makes everything go haywire, and they have to have a meeting. I call it a meeting.
Yeah.
Okay, it's court, whatever.
It's court with a television camera. That's all.
Yeah. Thank you, Robin. You rock, my mama friend. Oh my gosh, Tabitha. Oh, you guys put in the chat who got the memberships because it doesn't tell me up here on StreamYard. So let me know who got a membership from Tabitha.
A. Stevens did. He or she just said thank you.
That's so nice of her.
Very nice.
Shout out to all the OGs in the chat that have been with me all this time. You guys are amazing.
Bama is working it today. Thank you, Bama. She's been linking all your Sarah Boone content in the chat.
I've got the main, like all of her stuff. I've got that pinned up at the top too. So if you guys wanted to,
Hey, have
Thank
you guys
Barbara D.
all hit the like button? Because that would be fantastic. Lynette Porter. Has she been trying to add layers to the back of her hair? Has to stop. Thank you for your super chat.
I was thinking about that because what else can you do with that damn thing? That mop. I mean, it's just sitting there. It's like Cousin It. Isn't Cousin It the one that was the hair?
Yeah.
Mm-hmm.
Yeah. They want to know what Sarah just signed. Guys, I cannot see any better than you. Thank you, Tabitha, for gifting memberships. Jackie McLean says she's in the coffee club. Thank you. Thank you for your super chat from, looks like England or the UK.
Okay, you're getting to where I'm being able to put them on the screen.
They fly past me. Oh my gosh, Mandy Strong. She's still cuffed too. I love it. Yes, Leah wants to know what she's signing. I don't know. I can't see because the banner is blocking the table.
Hang on.
Yeah, we're hoping that we get different face cam views, LW, or different camera views, but I don't know.
Well, remember,
courtroom.
It was during we had really bad views, really bad angles when we were doing the Crumley trial, and then the day they started, Law and Crime had posted their own little camera up at the front behind the judge to look down at the. It looked down upon just the defendants. I think the way this courtroom is set up, they could probably pull that off here without any of the jury being noticed or anything. I'm in the coffee club. Jackie McLean, thank you. I got to pull that. I know. I pulled up. Where's my members? How do I find my members?
Emily H., thank you for your super chat. Carrie, every time your dog barks, I remind myself it's a tiny, spicy dog, not someone in the background with a horrible chest cold. Love you, mean it.
Oh,
so nice.
I'm so sorry, y'all. I don't know why.
Mark,
let me go.
Thank you for your super chat, Mark.
Let me go check on him and see what's making him bark this much. Hang on.
She had her hair done. That's the best supercuts could do. Okay. Then, yeah, I wouldn't recommend their services anymore. Mandy, thank you for another super chat. Sarah has cement bed head. Check it out. Yeah, it's not looking too great, is it? If they're signing a plea, I'm going to lose it. Yeah, right? After all of this? That would be crazy. That would be crazy. Sean Tierney said Margaret measured her wrong and forgot the staple gun. I don't know, guys. I have no idea what she's signing.
I'm back.
Okay.
All right.
Can
Let
you
me
take
go.
can you take the banner down because they want to see what Sarah's writing on.
Okay.
There you go.
It's her annual membership to Supercuts. He's like, see what's gonna happen.
Susan B,
Sarah.
all your money does go to Carrie. I do not get paid for this. This is not my channel. All of the hard work and all of the money is Carrie's. I have a job. She's kind enough to let me jump in here. Yeah, the fact that she's still look, she's turning really red in the face. Jennifer Goins wants to be a member. She'll sign up. Thanks. Canceling the box of wine of the month club. That makes sense. That makes sense. Plea deal is coming. Don't jinx it, Michael Robertson. That is so not fair. After all of this. Oh yeah. Laura, yes, you're correct. YouTube keeps a giant portion of the super chats. That's true. Oh, okay. Susan said she didn't mean me. Yeah, no, it's fine.
So Mandy said she's still corrupt too. Love it, love it, love it. And I guess she would be until today, until they make that decision. I don't know. Emily said, Carrie, every time your dog barks, that reminds me of, I know she just read this, but yeah, it's not me going, you would literally hear me doing that.
Ozzy,
Thank
no,
you
I
so
am
much.
definitely not. I'm not a slave. If anything, I'm the one that's
She's not a slave.
I'm piggybacking here.
Yeah.
I am a guest of this show.
Let's see. Mark said she had her hair done. That's the best Supercuts could do. Right? Oh, God, it's disgusting. I hate her neck showing. I think that's what bothers me about that haircut. It's her neck. It's like too short on the neck. Like they shaved up her head almost. It's a bad haircut. Even if it was in style, it would be a bad haircut.
Now the courtroom is still up on. I mean, we're looking at James Owens and Sarah. Mel's having issues. Let me look on my. No, long crime is still exactly what we've got up on the screen. So maybe it's an internet thing.
We are live. We are live with Law and Crime.
Mm-hmm.
Mandy said, oh, Mandy's got a lot to say today. Thank you, Mark, for your super chat. Mandy said Sarah has cement bedhead. Oh. Maybe she did try to put some kind of candy sticky in the back of it, and that's what's going on with the back of it right now, Mandy. Yeah, y'all are going off in the chat. Look at y'all. Always looks like a Bob's Burgers character. Amy. $7.99 watching here. Thanks for coming in and being. Is he fussing at her?
I don't know. Did that look adversarial?
It did look like it, didn't he?
I was reading chat.
Oh, I wish I could have read his lips on that one. Maybe he wasn't. He's just so animated when he talks sometimes. He's explaining to her what's going to happen. See, I'm throwing all this at the judge at the last minute in hopes that he'll take what we want him to take. But he's probably not going to take it. You're probably screwed and you're going to be found guilty and you are going to go to jail. Well, back to jail. But hey, We gave it our best shot. Here we go.
Oh, here's the judge.
Better not be a plea. I would freaking die if it was a plea. And just for the record, I've got the sound on, and Law and Crime is still muted right now. So they usually wait till the judge says we're on the record. All right, I'm going to mute.
Madam Clerk, I'm ready when you are.
David Ketchner on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
I do. Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger? Not on that motion. Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedure.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion? I believe the law of the case has already been settled on that issue. Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card?
Yeah, if you look in the very back. If you look in the very back,
okay,
you see the Miranda card. The last page and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I tell what you can?
Yes. I also have reviewed the 2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court for the clerk to mark A for identification is a DVD, emergency copy, it's the body worn camera.
And I have reviewed all of those in advance of today's hearing. Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1. Good afternoon, ma'am. Could you state your full name for the record
That's
and spell
Koepsell.
it for us?
It's Chelsea Koepsell. Chelsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center, the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Lowen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence?
Yes.
And later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes.
Do you see Sarah Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's up here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe that was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes? that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in an unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive? Okay. At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was.
And when was that?
That same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. And, so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house.
Prior to that, had she been detained and requested not to leave the scene?
One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to the window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending once the autopsy was completed the next morning was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Is it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right. So your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th. This interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's
Okay.
fine. You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I'll read from. You can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get?
Proper question.
Sustained.
Did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to following this motion,
I've become more aware, yes, that there's that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back?
No.
You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What
cause.
does that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response.
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection is sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection for relevance as to what probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th?
Objection for relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection for relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection. Relevance.
Overruled.
Yes, I did
Okay.
show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection. Relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car?
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection. Irrelevant.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video and the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, "I'm going to have you sit in the green chair"?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time.
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask, not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
She's picking the lint off her pants again. She's antsy. Where's her cell phone? She wants to check her text messages.
Have you noticed that she'll look everywhere except at Sarah?
That's called disdain.
Exactly. It's like you read my mind.
You may.
See if you recognize that document.
Yes, this is our waivers and affidavits.
Is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And is that form filled out as it relates to Sarah?
We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Is that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Yes.
Is that your signature or what?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
And that is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read or Miranda from those rights?
From this piece of paper?
Yes.
That's audio and video recorded? No.
Okay. You would agree that there's 9 questions on that form?
Yes.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9, Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
It's the right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
It's not us, it's law and crime. Thank you for your super chat, Matthew. Having 8 attorneys did not help her case. No, it did not.
I can't believe their feed just went out like that. First, we have the bad audio.
They need to get this together. Law and crime needs to go in and say, Judge Craddock, we know you're not a fan of people watching it, or, we know you don't care what the public is, being able to view this. He doesn't. Craddock's like, look, I'm taking care of my business. I'm not worried about the media. But he does need to kind of help a little bit here. All right, I'm muting again.
You would agree the situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay. That's all the questions I have at this time.
Any redirect?
Nothing.
All right. Can this witness be released?
I'd like her to stay.
All right. Subject to recall. Thank you.
We're not in trial yet. Good Lord.
State, you may call your next witness.
No additional witnesses or evidence in this issue, Judge.
Okay. All right. Anything from your side of the ledger, sir?
Of course there is.
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. Just that one.
Thank you, Miss Carrie Davidson. Good to see you, honey.
Carrie also gifted 5 memberships.
Oh, thank you. I missed that. Oh, wow.
What is it that's been marked as Defense Exhibit B?
Can't hear y'all.
Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you.
Thank you, Carrie.
Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument? All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously. And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department.
Do you know what page specifically those policies are on?
Page 14 of 22. I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next.
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
It's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence. Over objection is states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
Oh, snap. She's going to
She was
perjure
previously
herself
sworn.
now.
What? Did you see this coming?
No, but this is awesome. I'm so here for it.
Oh my God.
Yes, sir. Hang on, the deputy's got to move her.
It's all about the dramatics for Owens, you know. Is you think anything's going to really be accomplished here? This woman's going to perjure herself on the stand. We've got videotape.
Wow. I'm stunned. Look at you guys in the chat.
Are they going crazy in the chat?
Yeah. I'm loving reading them. All right, I'm going to be quiet.
Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it. Objection sustained and stricken.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Koepsell asked me was if I owned a phone.
And what did you tell them?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Koepsell.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Koepsell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Koepsell?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Koepsell told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Koepsell's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
You're eligible. Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
So did you call for a yes or no? She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Koepsell was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Right.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
She also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? Could you said normal protocol to her?
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space.
That all goes to whether or not.
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
But that goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
subjectivity matter under the case law.
Based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Koepsell that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Koepsell that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection? All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Koepsell's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
She's like, did we win? Did we win?
She knows she didn't win.
Mr. Owens, it's your motion, sir. You may proceed.
Is it over?
Not yet. I feel like we're at a. Oh, you
It's my understanding of the law regarding Miranda. First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Koepsell on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the 9th question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Koepsell goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Koepsell had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Koepsell's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Koepsell's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Koepsell has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, and for the record, those 2 exhibits that I tried to introduce, they will be admitted into the record?
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing. without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, I just want clarification, but she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table. Closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Okay. Police. All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm gonna have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court.
Please do in the courtroom.
And I intend on starting at 9 o'clock every morning. So I'll have pleas every morning and other matters because the court still has other business at 8:45. And I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir.
I love that.
Then the last item teed up for today is I'm sorry. Yes. Yes.
You guys, we're going to get to see her get her makeup put on every morning. That's going to be fun.
I cannot believe.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with
We know,
self-defense.
James.
And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You have a written order on the motion, protective order for tomorrow, as by tomorrow as well. Anything else, State, we need to address?
It appears, and again, been conducting motions all afternoon. It appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, All's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. If go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
I'm sorry, my poll was confusing. I know. I was thinking it out the wrong way when I wrote it.
Well, that was a lot.
Oh yeah, it took 2 hours to argue his little Miranda thing he's been talking about. What did he say about the custodian and supervisors? He's going to let them.
So
or he's going to do it tomorrow.
Are you asking what Owens was asking for, or what Jay was objecting to?
No, I'm saying, what did the judge say? Is he going to order it? He's going to put his order up later.
I think his order is going in tomorrow for everything.
Okay,
he seems to like to do his orders in writing for the most part.
Okay.
Yeah, that was a lot.
Oh.
I don't know what else to say right now.
3 hours later, and Mark said that Mark goes, his cracker is falling off of his cheese. He was talking about Owens, and my comment to that is, Mark, that cheese fell off his cracker and is sitting right next to his wine. Oh my gosh, I've never seen an attorney whine so much.
What did you think about that hearing?
Well, it was exciting for sure. I don't know. I didn't know they were going to do all this today. I didn't realize that they were going to bring in Koepsell. I didn't realize that Dummy was going to get on the stand. I mean, I'm like, okay. I'm loving the fact that she's been nixed on the Fantastic Sam's deal. Ain't happening. No beautification for you, lady, because even if we tried, it ain't happening. I love how the way Owens calls everybody a consultant. Have you noticed that?
No, I haven't.
So the one girl, when he was referencing, well, first it was Birkeland, right? Birkeland was going to be an expert witness. And now all of a sudden he's a consultant. Then he's talking about his two sidekicks, his seat fillers. And he said, one is now a lawyer. She's become a lawyer. The other one is
Consultant,
she's a consultant.
which
Yeah.
is code for in law school.
Yeah.
Because whoever wrote
exactly.
one of those motions the other night, I know I texted you about it, is textbook law school, just took the bar exam to the word. Like it's laid out so perfectly. I spotted it a mile away. So
yeah,
I think there's one still in school.
But he was like, she's a consultant.
Well, by saying that what's his name is a consultant and not an expert, then that changes what he's allowed to testify to.
Yeah, I get that. I get that.
Ugh.
Okay, my question in the chat should have been, do you think that James Owens is an egomaniac? Because he was driving me crazy with the way he was telling the judge what to do. He's like, give me a minute. Let me finish. I'm like, are you kidding me? You just said that to the judge. You just said that to the judge.
Wow. So yeah, I think that Chad's gonna say yes. Chad is 100% gonna say yes.
He
yes,
talks
he is a criminal attorney.
He talks to the judge as if the judge was his employee. That ain't Margaret sitting up there on the stand behind the bench with a gavel. You doofus.
That was a lot of nothing. A lot to do about nothing.
It was but what do you think the judge is going to do though? That's the main thing. Forget about all the show and everything that Owens just put on here. Do you think Cranick's going to go? I feel like with all of the objections and everything, I feel like Cranick's going to be like, yeah, no, it didn't hold water.
He's going to follow the letter of the law from whatever the case sources are. That's what he'll base his ruling in. So that is to say that he will be overruling or not granting Mr. Owens's motions.
I'm with you on that. I like that. I think so too.
But he will do it in such a way as there can be no question as to why. You know what I mean? That it will be well supported, his order. That's why he likes to go off and write them, so that he's so thorough and so detailed. I love him too. I think he's great.
Pinky says, I have a headache now.
Yeah, me too. Me too.
So the other question I was going to ask you is, I think we got to see a little bit of a preview of how Sarah's going to be in front of the jury today.
Mm-hmm.
The bad thing is that the jury is going to be seeing her for the first time, and they may believe it at first. Of course, once they see the videos, probably not. But it's like she was playing all sweet and dumb. But I still go back to the whole thing of the judge is the one that's going to give the sentencing, and the judge has seen her letters. He's seen her condescendingness, the way she is, how callous and calculating she can be, just, with dealing with her around this trial and everything. So I say keep doing it, Sarah, because it's not going to work. Because those videos of you telling George what you said to him while he was suffocating, that's going to do it. It's like you just said a while ago. It's a lot to do about nothing. The whole trial's a lot to do about nothing.
Mm-hmm. Yeah, well, so the state laid it out, that bottom of the guidelines, which in Florida we have a scoring system. I'm sure, do you guys aware of that? It's a point system for how long you get to go to jail for. So her score for what she's charged with plus any prior convictions, whatever points those would have been if she had any, will determine where she falls in sentencing. And so it's a guideline that is provided to both the state and the defense and the judge. Everybody's got it. And the bottom of her guidelines, which means the least amount of time that the judge can sentence her to, is 22 years.
The least amount?
Yes.
That sucks.
Did you hear him say bottom
Wait,
of the guidelines?
The least amount is 22. What's the most?
Yes. Life.
And is that with or without parole? Is that his decision at that point?
I believe I don't think it's life without. I don't think it's life without.
Where do we find that? Is that just something they decide? When do they?
No, it should. I feel like it should have been in the
docket.
It should have been in her charging documents,
which would be at the front of everything.
Ozzy says we don't have parole here in Florida, which I didn't realize. Oh, God. So I'm here in Florida. I work in the criminal defense world and just learned that we do not have parole in Florida. I didn't know it. I need a refund from my school.
No, wait a minute. We don't have parole in Florida?
Yeah, I guess not. We have probation. So they call it community control and probation. So what happens is, like, if you were, you can petition, I guess, for early release. Once you've done 85% of your sentence, if you've done it and not had any issues, you can try to get the rest switched over to community control and probation.
Oh, gotcha. Okay. And it's not like she's going to be worried about going and getting a job because, let's face it, she's never had one, so it's not going to affect her. She needs to stay in jail. They don't need to let her out. No. We cannot let her out.
Well, she could end up keeping herself in jail for a long, or prison, because that's what she will be going to prison. If she does not behave herself, if she gets into it with people in prison, she will get DRs. And they have little mini trials in prison, and she get write-ups, and she can buy herself. People get charges and get convicted while in prison for the bad behavior in prison. Did you know that? Did you know that could happen?
They can get more time added on. Yeah,
because if they commit a crime against a guard or another inmate or whatever, then they can be charged, tried, and convicted and sentenced for whatever they've done while they're in prison.
Can they write her up for tattling on other inmates? Because I'm sure she's doing that.
I bet she is doing that. And there's probably going to be a hierarchy to the prison system different than county jail. You got to remember that county jail is set up to be, it's not meant to be a long-term living space as it has become for too many people. And I mean, the pandemic was part of that. But it's meant to be a temporary housing. Prison is meant for long term. It's a completely different dynamic. Carrie asks Sam about points and Sarah's special circumstances. Which, oh, really? Was she charged with that? Special circumstances? Yeah?
I don't know. No. Hang on. Let's pull up the docket.
No, I need to. Where's her? Does she have any information?
Hang on. Let me share the screen.
Is a Florida jail better than prison or no? So, Amy, it's two different things, okay? Jail, like if you went out tonight and you got into a fight with somebody and you got arrested for it, you would go to county jail in Florida. That's where you would go until you were up for your first appearance and somebody come bail you out if you get bond. When you are sentenced to a crime that lasts beyond 365 days, you are going to prison, which is a completely different system. County jails are run by the counties. The prison system, I believe, is run by the state of Florida. Hold on, Carrie.
I'm trying to see if there's anything down here that says it says life. That's all I see.
Hold on. If I need to see, hang on one thing. I'll
I'm gonna
look
go
for it.
on.
I know what I'm looking for. I'll just see.
Okay, yeah, you should do that because I don't know what I'm looking for.
Yeah.
Hey, while you're doing that, let me just say something really quick. My gosh, you guys are just flooding the chat with super thank yous and super stickers and all that. And I just want to say thank you for that. Carla Perkins, Boss Lady, Mark Leach, Ella Blue. You guys, Mark's anniversary member. Thank you for that. Robin, Bubba D. Oh my gosh, you guys. Y'all were just, I've never had it this so many super chats or anything. Swab Phoenix. All these new members. Carrie Davidson. Let me go down the list here and say thank you for all of your super chats. Mark, thank you for being a member for 12 months. And I can't believe I put up with you that long. And now y'all can watch the chat and see how he comes back with that. JPC, thank you for your super chat. Carolina became a new member. Owens, Janice Wingfield, thank you for your super chats. I know you did several of them. Cindy Buchanan, thank you. Susan B, Mary Jo Freilich, Emily H, Mark, Mandy Strong had several. Barbara Seals, Miss Barbara, Jackie McLean. Did I miss anybody? Lynette Porter. Oh my gosh, you guys. Emily H, Ashley Kane. Y'all are just killing it in the chat. Matthew. I forgot about Matthew. Janice and Gia. And then Paul Berry and Addie. I'm not buying it. I'm not buying it. Bought a super chat. Hey, I did star a couple of things here. Cookie, if you're still on, Cookie, I want you to, if you can, find my email address and please email me. I want to ask you about something. I also wanted to look at a couple of things here that you guys had said. Yeah, Booberry was like, pull the microphone towards your mouth so that we can hear you. That's the one thing about these other trials and stuff that we watched before. The judge will say, please pull the microphone towards you. Now, the jury's not in the room right now. So maybe that's why he's not doing that. Hopefully,
as long as the court reporter can hear, that's their main issue, right? Is they want it, they need the record more than anything. But yeah, there's no jury there. There's probably very few people in the gallery right now.
So hopefully when the jury's there, he'll say, please, talk louder or pull the microphone or whatever.
Yeah, hopefully.
Roll with it said, thank you. You're very welcome. Thanks for being here. Mel said that Chelsea's baby is probably at least 4 years old now. Oh gosh, that's right. Oh, think about that. B Blanco said, you guys think Sarah will be able to control herself if she hears something she doesn't like being told about her? She'll definitely show facial expressions and stuff, I think.
But she'll be quiet. She knows. She will be able to, yeah. I mean, she might be mad at the lawyer and screaming at him later. She might write nasty notes. But do I think she will act out in front of a jury? I don't. I really don't. She knows better than that.
Can y'all see her little pen's gonna get quick? She's gonna be writing like crazy. She's gonna be writing hard on the paper and stuff. Polly D said that somebody definitely had plastic surgery. Are you talking about Chelsea, the Koepsell, the detective? I was wondering who you were talking about, Polly D.
But no, it could only be Chelsea.
It has to be. I mean, we know Sarah hadn't done it. Unless she's done it with staples. LWLW. It says, and they really. Oh, wait, see. And they really only gonna have a microphone for the judge. Yeah.
No,
but
so no. The witness stand that has a mic, and it looks like in this courtroom, the attorneys are supposed to go to the podium and talk into that mic. So hopefully they will do something about the sound for everybody else. But honestly, they don't care. As long as the jury and the attorneys and the judge can hear, that's all that matters. They don't care about us.
Carrie Davidson said, believing her lies, we're going to see a ton of crane act, and I love it. Yes. I do too. And you think I'm not going to do a t-shirt that says crane act? I dang sure am. I'm going to work on it this weekend. I'll have it ready to rock and roll by the trial. Let's see. I was trying to see if there was some super chats that came in while it was going on, and we weren't able to answer them. So let me just go back really quick. I'm not buying it. Thank you so much for saying that's really nice. We had the best chat. I mean, these guys are so funny, and everybody's so nice to each other. And Matt was like, "Yeah, they're wanting all this taken out, but she's the one that walked in and just started running her mouth." You're absolutely right. Addie said, "I don't know if I'm happy or sad. We can't see her dopey face." Talking about the cameras, I guess not on Sarah. Well, I don't know. I get tired of looking at her. Don't you?
Yeah, I mean, it is interesting to watch the defendant's facial expressions for sure, especially because I don't know that she can control her face very well. I can't control I try, but I think unless I'm really focused on it, I don't have a very good poker face.
Me neither. I wear it I wear my heart on my sleeve. It's all out there. You'll know, and y'all have seen it when I get upset about something. Y'all have heard it.
In court, I can handle it. I'm pretty good. I can keep that flat face going on all day, but in like my life, no.
Well, it's weird because like when I was in the business world, I could keep it together, but because I just get in the car and scream or whatever, right? But I don't know. I guess I should do that here. Matt says she's ordering a drink in Morse code blinking. I love that. That's awesome. I missed that one, Matt. I didn't know you
Oh my
did that.
gosh. Oh my gosh. What is going on?
Paul said she needs to fire her lawyer. Yeah.
She didn't hire him.
Well, yeah, true. She's not paying him, so it doesn't matter. And I don't think
he's not going anywhere. They can't,
right,
the
like
judge would never let him.
well, no, not just that though. I don't think she could get him to go anywhere. He's so crazy. I think he's crazy as she is. Batshit. Did co-counsel back out? Okay, so here's the deal. Co-counsel has been MIA since the very beginning, pretty much, except for on Zoom. And we do believe he said they're going to show up for trial. We'll see about that. Sam, what are your thoughts on the fact that he's brought his buddies in to help him on the case, and maybe they are doing some stuff in the background and helping him get prepared and all that? What are your thoughts though on the fact that none of them have really showed up and done like Beck? He's written a few motions, but we haven't seen him in court.
I think that announcement of more lawyers and all the things, I think that was a big show for the TV.
Mm-hmm.
I do not think that there was ever a need for 3 attorneys in this case. So I think that a lot of it was, smoke and mirrors, basically. I don't think we're going to see that big of a show again, like how he has made the past couple of times, because I think he's starting to see that it's not going well for him, and maybe he doesn't want the big show. You know what I mean? Like, you come in all full of fire the first time and you kind of get blown down, and then you get knocked down some more the second time. So he's scaling back his production. You know what I mean? So that it's less of a show. Obviously this is just my opinion, but the case is not so complex. I mean, your chat knows the case better than he does, clearly. Definitely knows the case better than I do. So, it's not to offend chat, but it's not that complicated, right? It's just not.
Well, I think he does some of it too, though, he does it for Sarah's benefit too. I think he's learned how to keep her settled. Like if he does certain things and it'll make her feel more confident or more seen or heard or whatever she needs to keep her shut up, Of course, I would bet that he's received some letters from her. They'll never see the light of day, though. We'll never see them, I'm sure. But that would be funny if we ever did. Oh, did you put something up?
I did. Sorry,
What?
I'm pushing buttons. I'm not supposed to, but I thought we should just address that.
Several people have asked if you go on tomorrow after the judge issues his ruling. Will we go on tomorrow? I don't know. Well, tomorrow's Thursday.
Mm-hmm.
I don't know. I guess we could. I don't know how. Let me see what I could put together. If I don't have a whole lot to present to you guys, then I feel like we'd just be sitting here going, do, do, do. So let me see what I can do.
Well, I guess you'd just be reading his rulings and letting the chat talk about it.
Yeah. I love how Blanco says, God dang, I might have to go get me a 6er. I'm like, ooh, I'm with you, dude. You know, I was kind of bummed because I was thinking, man, tomorrow would be a great day after I hear the hearing to go and lay out by the pool and have a beer or two and just kind of chill before we have to go into court for 3 weeks. And it's supposed to be cloudy and rainy here for the next 3 freaking days. And I'm like, oh, no drinky for me. I don't
Aw.
drink unless I'm laying at the pool. I don't drink by myself or anything like that. It says,
Yeah.
how did George feel that morning? Zephyr, I love Zephyr's insight. She always thinks about the victim, and you're absolutely right. And of course, with Sarah's antics and now with Owen's antics being thrown in the mix, the victim is completely unthought of. But I think we're gonna. You know what? No offense to any men, but women can be super sympathetic sometimes, and I'm really hoping that we have a lot of women jurors
Mm-hmm.
because I think women can see through other women's BS quicker too. What do you? That's not to be sexist or anything. It's just that women's instinctual women can read other women just like men can read other men better than women can read men, you know?
Yeah.
So what do you think, Sam?
Yeah, I agree. It'd be interesting. I don't know that the only way we'll get any information about the jury is if someone from court reports on how many people they are and what their ages are and stuff like that.
Please let the jury speak out after this trial is over with.
Well, that'll be up to them. They can if they want to.
I hope they do. I really hope they do. I started this one because I love. Do you guys watch Ab Fab? Ab Fab. It was on the Comedy
I believe
Central for the
it's
longest
still
time.
is that still on the air? Because that was on the air in the 90s.
No, they don't. They do reruns, but Patsy and Sweetie Darling. Oh my God, I used to love that show. It's freaking hilarious. But look, her avatar is Patsy, and her name is Patsy Stone. I love it.
Oh, got you. Okay. Got it.
And then we have Janice was saying that she just lied again. Exactly. She was lying on the stand today. She told the
Mhm.
detective she was not drunk and that she cannot get drunk in her deposition on that. She said she just said those things. Yeah, she's just a freaking liar. All of her lies are going to come out.
It was did you see her kind of waffling? I mean, she was working up to a big story. She was testifying, I was confused, my home, my son, my mom. I was still feeling intoxicated. No, I didn't have anything to drink that morning. Oh, yes, you did. There's no way.
I bet you money that the main thing they coached her on was not to say anything, like not to speak about herself, but to speak about others, like her son and George. It's because
But
you know
she
that's
was
like
saying a lot of I was feeling overwhelmed and I was confused and I was foggy.
yeah. So Laura says, with the way this whole case has gone, I wouldn't be surprised if after getting all the motions denied, they decide to do a plea. Okay, could it still be done? I guess it could. What are the likelihood? I don't think Jay and I don't think I don't think they know they got a winnable case. I just don't see them giving her a plea. What do you think?
That's the exact thing. That's the exact thing, Carrie. There is no plea if the state does not offer a plea.
Right.
And she missed that right off the bat. So the very first time that it was told to her that she was going to be on her own, they mentioned the possibility of a plea deal. After that, they never said it again.
Yeah, and it's definitely not going to get brought up again, especially with Owens is losing at this point. If we were keeping tally, he'd be at the bottom of the barrel. Matt's going to get the wine ready for trial. I tell you what, I might have a glass of I might have a beer during verdict.
I think we're going to have a really drunk chat based on the planning that I have seen going on today.
I
So that
know.
ought to be really entertaining.
I'm over here talking about snacks and popcorn and everything else, and y'all are talking about flipping drinking alcohol. I
Yeah.
can't drink on stream. I won't do that. I say that now, but I just don't think I should ever do that. I've seen some people that have gotten on YouTube and should not have.
Yeah, exactly.
Gia said, "Thank you for our coverage. You are so welcome." Is that your little baby's behind? We see right there, your little boo boo. That looks like a Chihuahua or a Corgi. That's so cute. Janice says, I want a camera facing the defense table. You know she is pissed. That was early on when they were still talking, and
Yeah.
he kept getting shut down. I agree. I agree. I agree.
Sam is Laura's agreeing with me on something, but I don't know what because I can't remember 2 minutes ago.
Thank you, Carrie Davidson, for buying those memberships. I appreciate you. And you guys don't forget to thank Carrie if you got a membership. Matthew said having 8 attorneys did not help her case. No, it did not.
No, it did
And
not.
she has 3 right now, but as we just spoke of, we
Well,
don't think so.
Did you catch that that the state said that they were just getting medical records given to them now that they knew Billy had gotten for her in 2021? Did you catch that?
Hang on, I was drinking my drink. So wait, are you saying that the defense has been sitting on them?
Yeah, nobody apparently. Okay, allegedly, apparently. No one has turned them over in reciprocal discovery. So what the state just said is, hey, the defense has had these medical records since 2021 because there's a record of that. And they just got them. Amy 55 agrees with me. Thank you. I know I'm not super crazy. Okay. Yeah. Yeah.
Thank you for being here, Ashley Kane. We appreciate you.
Thank you.
Don't get fired from your job over
Oh,
watching. Sarah's not worth it.
She's one of my body doubles, I think.
And Mandy, did you leave the chat? She says she scratched the jail logo off her shirt.
Yeah, that was really early on.
Yeah, but I haven't seen Mandy chatting since. Did she leave me?
She might have left.
For anybody that decided to leave because of the audio, I'll have you know it wasn't my audio, it was theirs.
No, it wasn't. It wasn't.
Mark said she had her hair done. That's the best Supercuts could do. No doubt.
Yeah.
I think we've gone through the rest of them already.
Yep.
So, wow, 3.5 hours of sitting here listening to this. Most of the time, if we were to have done a counter, I would say Prosecutor Jay probably spoke for 20 minutes total. The rest of it was all, what's his name? He just kept on and kept on.
Yeah, more words does not equal a better argument. And yeah, sorry to everyone about the audio. It's horrible. And there's not really anything we can do. It's just as bad for us as it is for you.
Look at what G-May said. You break out in cuffs? Oh my goodness. Well, is the cop hot? Because if he is, then it's worth it. Sarah also lied and said she called 911 first. Oh, you're so right. When did she say that? Today? Was that today, or which? Did she say that in the interrogation? She always lied about that, but you're absolutely right. We know she called Brian first because she let a lot of stuff out of her mouth before she realized she shouldn't have.
Yeah, for sure. Could you please explain why research from one lawyer could not be passed off to the next lawyer? At least Sarah said. It should have been. It could have been. There's no reason for it not to be at all.
I thought it was interesting how Bankowitz has jumped on the Owens train, and he's all offer what Owens is doing now. But you haven't heard anything from the other attorneys. They've all kept their mouth shut.
I didn't even see the latest James Owens interview because I put myself into YouTube timeout. So I need to go back and watch some things.
Was that the one with him and Bankowitz together?
Yeah,
He didn't say anything. He said the same thing that he said in court. Dr. Julie Harper, battered spouse syndrome, Sarah's not guilty. I don't know, whatever. I mean, he says the same stuff over and over again. None of it is ever worth a flip.
Okay, can I answer this question from Maddie? Do you mind?
Yeah.
Is this okay? Can I answer this?
Yeah, go ahead.
Okay, so Maddie says, could you please explain? Sorry, but I still can't wrap my head around the fact that motive does not matter. In the state of Florida, and in fact, everywhere, I think, but I can speak to the state of Florida, motive is not an element of a crime. it's not, you don't ever have to, the state doesn't ever have to prove it. So the state has the burden of proving each and every element of the crime charge beyond a reasonable doubt. The elements are laid out in the statute. Like, the person had to be dead, you had to have something to do with it, whatever those things are. They have to prove those three things. Motive is something made up for TV. Maybe it helps you look for different people, but it's not ever required, not here in Florida. And I was stunned when I learned that in law school. So,
Well,
yeah,
but I think too, well, you hear motive in regular court feeds too, because it also helps the jury understand, because sometimes it's like with Sarah's, we kind of go around what was her motive, but in some cases it's absolutely obvious what the motive was, like, especially if there's like a life insurance policy or something like that involved.
Right. Well, I think the jury absolutely lives for a motive, right? But it's not a requirement. Motive, you don't have to prove motive. You don't.
Alexis brings up a good point. I guess on the next, when we go to trial, I'm going to need to put the chat in slow mode, and a lot of people are not going to like that. But I think we might have to, unless I give out more wrenches, and I think people like to enjoy it. They don't feel like,
Yeah,
poor
they don't wanna
Laura
police
and
it.
Bama are working overtime.
I
I
need
gave
to figure out how to get myself in as myself. So
Yeah,
I'm
you
not,
do.
so I'm not you.
Mel, I handed you a wrench today without even asking you if you wanted one, but I figured that if Laura and them got overwhelmed and somebody needed to be booted, you could do the job. I trust you to do it. So
They're saying it's okay about slow mode. They understand.
yeah,
It's
I
a
just think
lot.
it's better.
It's a lot for us. I mean, well, I'm going to speak for myself. It's a lot for me to listen to what's going on in court, try to process that, and then watching what you guys are all saying.
I couldn't even keep up with the super chats today, and when they pop up, they're colored. So, I mean, I was like, oh my gosh. To try to keep up with the ones that aren't highlighted, it's like, wow. So
I'm fascinated by the chat. So, to be honest, I'm paying more attention to chat than I am to the court.
well, speaking of which, how about we go through and we let you do some legal Q&A with the chat right now? Is there anything in there you saw you wanted to answer, or?
I don't know. Do any of you guys who are left, who are still here, do any of you have any legal questions? Sam, can you explain what a score sheet is? Oh, okay. Sure. So in the state of Florida, we have what's called sentencing guidelines, and there is a score sheet, and it's just like what you would think. Different crimes equal different points. So it's like kind of like getting points on a driver's license. The more points you rack up, the worse it is for you. So if you have a criminal history behind you, that all those points from those convictions, those get added to whatever you're being convicted of now, and that helps to determine your sentence. So judges don't have a free-for-all in deciding what can be sentenced. I hope that makes sense. Did that make sense to anyone?
Ozzy had a decent question.
Okay.
I'm curious about this too. How do you prove perjury?
Perjury is lies.
Yeah, but how to prove it?
Well,
I mean,
so
other than the fact that she got audio.
What they're saying is she would commit perjury if she got up there and said the absolute opposite of everything she said in the audio interviews that the whole world has heard.
But she's going to do that.
That's perjury. She can't. And her lawyer technically can't suborn perjury because they would get in a lot of trouble for that. So if she's going to get up there and lie, right, and commit perjury, she's going to testify in a narrative form. Owens can't question her because he would be soliciting lies from her. So, yeah, that's where the issue is. There is, he would have to he would have to testify in a narrative form, and we've seen that happen in a couple of trials recently.
Bama, which by the way, Bama, Laura, and Mel, thank you so much for helping out today. I appreciate you guys so much for moderating. You guys make sure y'all give them some love in the chat. Bama, I really wish I could hear Sarah and Owen's conversation tonight. I know. Do you think she's mad at him? Do you think she's going to fuss at him? And do you think he plays this little, you think he plays her like, you know how some men will play a woman and she'll believe it every time?
I don't know. I don't know how this is working out, but my guess is that neither one of them holds back words.
Yeah, that's true. I think he'll give her a little bit, but he also will coddle her to make her feel seen and understood. I feel like he's the type that can manipulate real easily.
Yeah, I think he's probably a manipulator. And I
Like,
think he brought the girl. I'm sorry.
No, go ahead.
I thought he brought the girls up last time as part of the show, right?
Mm-hmm.
Like he needs this team of assistants, but also to like make Sarah look important, to placate her. Okay, I'm starring some questions.
Okay. Well, I wanted to say something.
Oh yeah, please do. It's your channel.
No, I mean,
Sorry.
no. I just wanted to say, I feel like what Owen says, a lot of us listen to it and just could hear the BS screaming off of it, right? But somebody like Sarah, if she hears positive things about herself like that, she's like totally blown away by it. She's like, she's just that type of person. All right, go with your questions. I'll shut up now. Go ahead. I'm gonna take Bama off. You can put your questions up on the screen as you answer them.
I starred them, but I don't know where they went. Oh,
Well, hang on.
Oh, I got it. I found it. Hold on.
Okay.
But are they at the bottom?
I'll look and see if we got any more.
Okay, yeah, they're at the bottom here. Okay, so show. This is Susan B says, at Sam, I didn't catch that about medical records, gonna rewatch. So she had a couple trips to the hospital from like that leg injury, and what the state said is that Billy had gotten her medical records back in 2021 and made a record of getting the records in 2021, and the state just now got them, which means that of all these attorneys, no reciprocal discovery was ever done, which is a lot.
Wouldn't there have been, what was the deadline for them to get all that in, though? It was well before today.
Oh, it should have been done ages and ages ago. Remember, I work on the side of the defense, so we rarely have reciprocal discovery, and we're always begging the state to give us our discovery. So, it should have been done by now. I mean, there's just no reason for that.
Let me put up Janice's thing real quick, because she said, hang on just a second. We'll put Sub Rosa back up. Janice did a super chat. She said, Sarah said that today on the stand about calling 911 first. Okay. Thank you for clarifying that, Janice. I hate that you had to do a super chat for me to see it. I'm sorry, honey. Thank you, honey. Okay, go ahead, Sam. Sorry.
Okay. Sub Rosa has asked, would allowing makeup set a precedent? Would it become case law? So it might set a precedent. Would it become case law? No, that's not how things become case law. It has to be
case law.
There has to be it's a story for another day. Case law comes from appellate courts and from appellate issues, which come out of the trial courts. It's like a staircase problem. You build and you build and you build until you get a panel of judges making a rule, and that's case law. So makeup is not like a constitutional question. So I'm going to go with a no on that. Let's see. Angela Nygaard, I want to know why Owens won't cite case law to support his arguments. Because he's lazy? I don't know. Let's see. Ozzy, this question is regarding motive and it is a state of mind things, as in I believe this, so it is hard to prove. It is a state of mind thing. Okay. Yeah, okay. I think you're asking.
I don't think that's a question.
Is it a question? I don't know. It is a state of mind things, as in I believed this, so it's hard to prove. It is a state of mind thing. Regarding motive, yeah, I mean, it is a state of mind. That's true. And yeah, you might not be able to prove a motive, but you don't have to. So,
Wait a minute. Tam Tam says, are you talking about the medical files?
Yeah.
Because she said Mr. J said that they got those files in 2021. Miss
Yep.
Cashman said she got them and they had Sarah's handwritten notes on the records.
Right.
But
the
you're saying
state is just now getting them.
no, but she's saying Tam Tam saying Mr. J said they got them in 2021. Oh, never mind.
No,
Okay.
he's saying that the defense had them in 2021.
Oh, my bad. Okay, go ahead. Sorry.
No, you're fine.
I'm looking for questions while you're doing that.
That's why I'm just scrolling looking for questions. What is a gifted membership? I don't understand how that works. Or costs. You can answer later. I'll let you answer that one.
Yeah, I get that one. Okay, so when you go down to the bottom of the chat section where you would type in your chat, right below that you'll see like 3 different things. You'll see a plus. Well, you might not see a plus sign, but you'll see a dollar bill sign. And you click on that, and it'll ask if you want to do like a super chat or if you want to buy a membership. And you can buy a membership just for yourself. You can do a super chat, or you can gift memberships. And I think you can do 1 at a time, 5 at a time. I'm not sure how many. I think it's 1, 5, and 10 at a time. But yeah, you don't get to choose who they go to, unfortunately. You do it and YouTube just distributes them. I would hope that YouTube distributes them to the people that are on the screen at the time, or I would hope that they gift them out to people the people that are on the channel the most. I would hope.
I think it's people who are currently active in the chat at that time.
So that's kind of the way it works. But yeah, so if you don't get one, you get your feelings hurt that you don't get one, because it's not like they're trying to avoid you or anything. It's a YouTube thing.
Well, she was also asking what are the costs and what is it for? So it's to help support the channel. It supports Carrie. And you basically are agreeing to pay for a month, and there's some behind the scenes stuff or whatever she decides to put up.
We do. Every now and then I'll put out a video that members get before everybody else does. There's one right now that we've done that on. But at the same time, I think mostly what I want to start doing more than anything is having interactions with the members on a regular basis, at least once a week. And so that's something I'm looking forward to doing. There's also some items that I can put out and show the members, like in videos that would be members only videos. And I'm going to be honest, when I first set it up, I really had this great, I'm going to do this, but it was hard to do that for me. So, I need to work on that. I know a lot of people, when they buy a membership, they think of it more as like a tip. It's like a monthly tip to the creator. Another thing too is that the cost of them, I think they start at $1.99, and there's levels. There's like $1.99, $5.99, and so on and so on.
Yeah,
but yeah, you get to choose what you want. But I'm going to tell you right now, pretty much all my levels, I treat them all the same. You buy a membership, I treat you the same as you, and that's just, I don't know. I just kind of believe in it that way.
So Amy55 is asking if you have a Cash App that they can use instead, so money doesn't go to YouTube, it goes to you.
I do not. I have what's called Buy Me a Coffee, which is in the description section of all of the videos, so you can use that. I've been using that for quite some time, and I like the privacy setting of it and everything. And I can also, once you become a supporter via that, when I send out an email through there, you'll be copied in all the emails that go out too, because you're considered a supporter under the Cash App, not the Cash App, but under the Buy Me a Coffee. So just look for Buy Me a Coffee /characters. And that's where you can find that at. And that is 5%. They take 5% from me. Whereas YouTube takes, I thought it was 50, but I think YouTube takes 30% on anything done on YouTube.
Okay, I've got some other questions.
Okay.
I'm confused about the makeup thing. This is Travelin' Teresa. Judge K said she could do it in courtroom, but then deputy said it was against jail policy. So does she get it or not? No, because bailiffs are in charge of her.
Owens is confused too.
No, she doesn't get it. The deputies rule basically when it comes to anything having to do with custody and transportation and clothing and whatnot. And actually, I thought it was odd that judge said to take the clothes to the jail, because we bring them to court and the guys change right in the holding cell right off the courtroom. So I don't know, different courts do things different ways. Hot Patootie, bless my soul, has a question. Do you think the state will file a motion in limine to keep out battered spouse? Didn't they already do that?
To keep it out?
Mm-hmm.
Yeah, they tried to say, well, you got to pick one or the other. You can't do both. And
Yeah, I think they already tried to argue this, and the judge said that he's keeping it.
Judge said pick a lane, and they picked the battered spouse lane. So yeah.
Let's see. I had like 2 more.
Oh, it said Tito's and lemonade for trial, and DoorDash. Oh, I'm out in the country. I don't get DoorDash anymore, but I used to love to get DoorDash.
I'm gonna let you read this one.
Okay. Questions. What do you call a parrot that practices law? A paralegal. Bwah ha ha, Ozzy. That was a good one. That was a good one. Aw, thank you, Linger. Another sweet super chat. Y'all are so sweet.
Ginger Snaps says she had fun. Thank you. Thank
Leah
you,
said-
everybody. Our mods were amazing. You guys are fantastic.
Leah said, I'm going to have my special gummies on hand. What kind of gummies are those, Leah? Are they the real gummy bears? Or are we talking about some other kind of? Can I tell y'all? I have to tell y'all a story really quick, if you don't mind. So my sister is like high strung. Like if y'all think I'm high strung, my sister is like well over high strung. Like everything in her house has to be just right. Okay. So we always make fun of her because if y'all have ever seen Monica on Friends, my sister's Monica. It's like if we move a piece of furniture, we all look at each other like, you just moved the furniture. You want to put it back really quick before she has a fit. So one day I'm at the tobacco shop getting some of sometimes I'll roll my own cigarettes. And so I'm at the tobacco shop and I see they have gummies and I never bought any. And they're the kind that are legal, but they've got a little bit of happy stuff in them.
Mm-hmm.
And I thought about my sister and I said, I'm gonna get her. And I didn't know there was 2 different kinds or levels or something. So I said, okay, I'm gonna get 2 of them. I'm gonna get one, this level and this level. And then what we'll probably do is maybe one Friday night or one Saturday at the pool, we'll cut it in half and we'll both do them together, you know? My sister takes one to work and she pops it the first morning at work, y'all.
Oh, what?
She had no clue what she was doing. She was like, I didn't know. I was like, Shannon, you don't know? How do you not know?
Oh, wow.
She said it was the longest day of her life.
I bet. Yeah.
And especially somebody that's not used to something like that, you know, my sister doesn't. She'll do wine, but that's all she does is wine.
Yeah.
Okay, go ahead.
So both Traveling Teresa and Northwest are saying they believe that Mr. J said, and I don't disagree. I didn't catch it, that Mr. J was going to object to battered spouse again. And Northwest said, I think the state will file another motion. I didn't catch that part. I caught the medical records piece. And let me see. Did I have one more?
Oh, hey, Northwest.
I don't know. I think that's it. Did I get everybody?
I'm not buying it. Said Jay was tame today. If Sarah thinks today was difficult,
here's
wait until
one.
trial. Oh yeah, girl.
Bama wants to know about that syringe.
It doesn't say in the police. Okay, so let me explain the story so everybody that's here understands. In the police reports that I received from the Orange County Sheriff's Department, I'd asked for a bunch of stuff that was unredacted. And in that, they go into detail about what was found in the suitcase with George. One was a necktie. So there was a couple of shirts and stuff in there. His ball cap was in there. I think it was the ball cap he was wearing. And they mentioned a syringe of diazepam. And I'm like, what in the hell would a syringe? So I look it up, and a syringe with what it is called? Diazepam is, you had said it was to help people when they're trying to stop drinking.
I think you looked that up.
Yeah, but I can't remember what I said. I was hoping you would.
Yeah, it is. It's something that, but I think it's also Valium.
But it's, yeah, there's a lot of other, everybody in the chat was going off about all the things, the different side effects or what it does and this and that. And so it was interesting, but I guess what Bama's saying is, number one, why was it there? And number two, was it empty or opened? And it doesn't say whether it was opened or if it was anything. It just says it was there. It doesn't say it was full. It doesn't say it had been used, nothing like that. As far as why was it there, Sam, go ahead and tell him what you think it was for.
What did I say?
You said you thought it was part of his parole thing that they
his probation. Yeah, it could have been part of his could have been part of whatever, because she said that he had been going to his classes and things. And do you remember that, like in her interrogation? So he's got a probation officer. So it's possible, I don't know this for a fact, it's possible that it was part of him trying to stop drinking.
I think that's probably what it was. And that's probably why it was in the suitcase not being used. But see, somebody else said,
I think it was in his pocket. I think
you think it was in his pocket?
Uh-huh. Yeah,
Interesting. Interesting. We'll find out. Ginger Snaps. Crap, after today, I want to spike Dr. Pepper. Me too.
Classes come with benzos. Guys, it's a speculation because it was empty. I think it could have been in his pocket. He might have taken it earlier that day. I don't know. I'd have to go and look and see what the conditions of his DV was. But the thing is, you can't see DV because it's protected. So I probably couldn't even do that.
Tabby, in her in the police report and in her audio and stuff, she did say she called her husband first before calling 911.
Mm-hmm. Judy T has a speculation. You should have come to Salacious Speculations the other night, Judy. I think George was actually trying to stop drinking. I think when he went to Publix on his own, he told the clerk the wine was for Sarah and he wanted to leave her, and that's why his testimony is redacted. Okay, that goes in the speculation pile. Tanya is asking, doesn't trial start on Monday? Yes.
And we
Jury
will
selection.
be here for it. And we don't know if we don't know if or how much of jury selection they're going to show. It might be one of those things to where court TV's there and half the day we're looking at the ceiling.
Right.
So I'll try to get some stuff prepared for you guys so that we can at least have something to keep us busy and something to watch, and then still be like, as soon as they come on, we'll be there for it.
Mm-hmm.
I made something for you guys I wanted to show you really quickly. Let me
I could distribute some of my casework to chat if they would like to go through it.
Yeah, they would probably love it.
I know, right?
They would probably absolutely love it because they get into this stuff so much. Okay.
I know. You guys, I've got thousands of pages, plenty to share.
Okay, so I put this together today, and I'm trying to think of who it was. Was it Fan Lady that gave me this idea? Whoever, if you're in the chat and you recognize what I did here, tell me that it was you.
Found it before you called. Yes.
Are you claiming self-defense? Yes.
Found it before you called. Yes.
Are you claiming self-defense? Yes.
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 I think that's so funny.
Oh, God. That is too funny.
Am I the only one that laughs at me? I'm just wondering.
No, I think you're funny. Oh, all right. Well, I'm going to jump off of here.
All right, Miss Sam. Well, thank you for coming.
Thanks to everyone. This should be an interesting journey, I would think.
And I think we're gonna go ahead and close it out. I think we're all tired. Oh my God, I'm laughing out loud. Thank you for laughing out. Oh, and Judy T, I want to tell you too. If we do I think what I'm gonna do is next time I do something where it's members only, or we'll do a members only live. So if you're not a member, you won't be able to get in. But then we'll do other things where it's members, and because that was kind of hard the other night trying to put members before somebody that's not a member but's a subscriber, because sometimes I couldn't tell who was who. So yeah, that was I didn't realize how difficult that was going to be. I thought it'd be a lot more easier. So play it one more time, please. Okay.
Found it before you called. Yes.
Are you claiming self-defense? Yes.
Found it. Before you called? Yes.
Are you claiming self-defense?
Yes.
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 It is really funny. I'm tired and I'm still reading chat.
I
Oh
cracked
my
myself
God.
up.
It is funny though. It really is.
It's pretty bad. It's pretty bad when sometimes I'm going back and editing stuff and I hear something that I think's funny that I did and I laugh at myself. It's so bad. Are there any women here? This isn't a pickup. This isn't a bar. What the hell, Sub Rosa? Are there any women here? We're mostly women on this channel. My my analytics on my channel says that I think it was
that this was a quote. I think this was a quote. Are there any women here? I think she's quoting somebody.
Oh.
I think, did Owen say that today in court? Are there any women here? Because he was like looking around trying to get confirmation on makeup or something.
Oh,
I feel like maybe we missed something there.
Yeah. I missed it. I'm sorry. Sometimes it takes me a minute. I'm blonde. Okay, yeah, the next trial date, it's already set up on my channel. Make sure you go over there and hit the button so that you'll be notified when we go live. If it starts at, if they're saying the jury is going to start at 8 o'clock in the morning, regardless of your time zone, if it says 8 o'clock in the morning for the trial, I'll be there at 8:30. So, I mean at 7:30. So just know I'm going to try to get in there 30 minutes early at least. And bring all of your snacks and your popcorn and be prepared. Get your catheter, whatever you need. I think I'm going to need a catheter. I probably am.
Oh, here, Sub Rosa explained herself. Where did these go that I tried to put them up? There it is. That's a quote from Monty Python and the Holy Grail.
Oh, I'm sorry. Okay, thank you. Yes, have a wonderful day, everybody, and maybe we'll be back on Friday night with some more fun interactive stuff. Okay, love you guys.
Bye.
Bye, guys.